So I'm going to talk today about provisional relief in pharma litigation under the UPC system. So as you may already know, provisional measures are urgent and temporary remedies ordered by a court to prevent or stop unalleged infringements without waiting for a decision on the merits. They mainly aim to avoid irreparable damage to the rights holder due to infringements such as price erosion or any loss of market share. This is true for all of the technical fields, but pharma fields has some specificities, mainly because it is a regulated market. So a lot of drugs have a fixed price and a reimbursement rate, which is negotiated with national regulatory authorities. For example, in France, the launch of a generic drug has an impact on the price of the reference product because it decreases for 20%, irrespective of whether the generic product infringes IP rights or not. And it should be stressed that this decrease is not reversible. So in this context, getting a preliminary injunction before the launch of a generic drug is crucial for innovators' lab in order to avoid a definitive price erosion. A brief overview on conditions for the grant of provisional measures. They find a legal basis in Article 62 UPCA, as well as in the rule of procedures. Four main cumulative conditions for getting provisional measures can be found in this text. First, there should be a presumption of infringement or of imminent infringement. Second, the title at stake should be more likely valid than not. Third, the provisional measures should be necessary. On this condition, the judge assess the interest, assess the balance of interest of each parties. And last, the applicant should have seek this provisional measure without any unreasonable delay. Today, we'll focus on the assessment of imminent infringement through the case law Boehringer against Zentiva, which is a landscape case law from the Court of Appeal of the UPC. A brief summary of the fact: Boehringer Ingelheim held a patent, a European patent covering a therapeutic use of nintedanib for preventing or treating a specific pulmonary disease. This patent expired in December 2025. And Boehringer, of course, commercialized a reference product, Ofiv. On the other side, a generic manufacturer, Zentiva, obtained from the Infarmed, which is the Portuguese national authority, two market authorization to commercialize a generic product containing nintedanib, which is the active compound of Boehringer. This market authorization was obtained in August 2025, so 18 months before the expiration of the patent at stake. Then the Infarmed issued a price and a reimbursement rate to Zentiva for this generic product in December 2024. Then Boehringer applies in early 2025 for provisional relief before the local division of Lisbon. So at first sight, the local division does not grant any provisional measures. This decision was overturned by the Court of Appeal in August 2025. So what was the reasoning of the court on this case? The Court of First Instance stated that it is customary for generic manufacturer to apply for MA, as well to seek for a price and a reimbursement rate before the expiry of the patent. This point was not overturned by the Court of Appeal because it is part of the Bolar exemption. It is interesting to note that the Court of First Instance considered that the early application for a price and a reimbursement, which occurs more than 1 year before the patent expiry, was not sufficient to demonstrate that Zentiva intended to enter the market before the patent expired. And on this point, the Court of First Instance concluded that there was not imminent infringement. The Court of Appeal adopted different reasoning. They consider that the completion of pre-launch operations, such as obtaining a price and a reimbursement rate, can amount to an imminent infringement depending on the specificity of the case. In this case, early completion of these proceedings has no other objective than offering on the market the generic before patent expiration. The Court of Appeal defined a legal test to assess imminent infringement, specifically in the pharmaceutical fields. The question is, has the potential infringer set the stage for the infringement to occur? So that infringement is only a matter of starting the action of infringement. And it is interesting to notice that the Court of Appeal proceed with a detailed review of what the generic manufacturer can do after obtaining a price and a reimbursement rate in the national market. So in this case, it was Portugal. The court investigates whether other administrative steps were required to commercialize this generic drug. In this case, there was only a pre-notification to the regulatory authority, but as it was only a declarative action, and as Boehringer was not has no guarantee to be aware of this pre-notification before the actual launch of the generic, it cannot be a basis for requesting provisional relief, as it is too late. The Court of Appeal also investigates what kind of pre-contractual act Zentiva, the generic manufacturer, could be initiate, and they consider that every participation to public procurement procedures, to public tenders, constitutes an offering pursuant to Article 25, so it is an actual infringement. And as Zentiva was not prevented from participating to such procurement tenders, except then voluntary self-restraints, Boehringer has no guarantee that the generic would be launched before the patent expiry. Also, another point is that Boehringer has demonstrated that the generic could be commercialized outside of the scope of a framework agreement through direct sale to private hospitals. So, in view of all these facts, the Court of Appeal considered that a preliminary relief should be granted because there is a real risk of imminent infringement. So a little summary of when can we get preliminary relief in the pharma field. So on the one hand, when a market authorization is granted, it cannot amount to imminent infringement. This is constant case law and in line with national case law because it is part of the border exemption. On the other hand, any market access operation, such as participation to public tender, may be considered as infringement act directly. So preliminary measures should be granted for that. On this aspect, it should be noted that it may change in the future because the border exemption will be extended through the disposition of the new pharmaceutical package, which will enter in force within the next few months. And the cutoff, the current cutoff is after the obtention of the grant of a price and a reimbursement rate. And any circumstances on the case should be assessed to grant or not provisional measures as it depends on the country national regulatory specificities. So what key takeaway and practical advices can we extract from this case? As in every UPC case, time management is crucial because application for PIs is a one-shot opportunity. So we can advise to start to prepare application for PI as early as possible by gathering evidence, but only file this application when the generic manufacturer has lifted all regulatory barriers to market its generic products. Another point would be the training of competitive intelligence department to ensure a smooth and fast communication with the IP and legal team, because it is important to act quickly and without undue delay when requesting such preliminary measures. Seeking support from specialists in national regulatory systems is an important point, as the UPC would study in detail the national regulatory framework. And a last point, which is not directly related to Boehringer against Zentiva case law, is proceed with rigorous due diligence review when acquiring acquiring IP portfolio, because as it is highlighted in another case, Merck against Viatris, you should be aware of any pre-launch and regulatory operation of your competitors, and you cannot say, I was not aware of this competition on Scape. So that's all for my presentation. Thank you very much for your attention.